in order to avoid criminal actions taken against him for statutory rape. So the time frame for getting this reported to our principal is very short now. I'm going to take another comment, please.
What if she's 18 so she's not a minor?
It's a good point. If she's 18, in this instance, we're looking at a child who's 15 years old. But if she is 18, then she is by law able to give an informed consent. So the age of the child becomes very important. We want to know, as you know, the range of ages in a high school would probably be anywhere from 14, 15, up to 18. So the age of the child becomes a very important fact in this scenario. Thank you for that. One more comment.
When does the parents get involved and when does the counselor? So if you want a student to go to a counselor possibly to see really what's going on, or the teacher you go directly to the principal first. When do you go out, the parents and the counselor? The child may feel uncomfortable, especially being a girl. She may want to talk to a female psychologist, counselor.
It's a good point. The question is, at what point and how soon do we bring in other school district personnel, like a school psychologist? We want to start with our on-site principal or vice principal. The thing that principals and vice principals hate most is being the last to know. The police are at the high school. They're in the process of handcuffing Mr. Smith, and the principal has not a clue. You could see how you might be on the carpet with this one. So let's start there. They're being paid to advise you. In most incidents, they will want to contact police themselves to make sure that an accurate record is filed, that things get handled very quickly if this child is in fact underage. I'll take one more comment and we'll look at...
But even if they're reporting you off, so you have as the first person hearing it you have legal obligation to report also?
Yes, yes. You're going to have a legal obligation to report as well. Your notes around this incident is going to be very, very important. What did she actually say to you? What were her thoughts and feelings around the incident is very important. As soon as the principal has been informed, it's best if he informs the parent. That's what he gets paid to do, is to have very formal interactions with parents. So let's let him initiate the dialogue with the parents. They will certainly want to pull you in and get as much information as you have about this incident. Is the school employed? How about this instance where you as a teacher know that Mr. Smith is having sexual intercourse or is sexually harassing innocents? We talk now about your responsibility to get the facts, to report it immediately. Many times employees are afraid or nervous about, as they say, snitching or telling on another employee. Our first concern has to be for the child. If Innocence is in fact 15, she is an innocent victim, and our responsibility is to protect her. Mr. Smith knew what he was doing, and so our loyalty is to our students rather than to a colleague, even if it's our best friend, to report this incident of misconduct and sexual harassment. Can the school district be held financially liable for Mr. Smith's conduct? Well, there's a good possibility if Innocence is in fact 15, Mr. Smith is going to be arrested and tried for statutory rape, and if found guilty, will be incarcerated. What's going to happen to the school district? What's their liability? I want to take a look now at the Supreme Court decision in the Gebster case. Based on a 1998 Supreme Court case, Gebster versus Lago Vista Independent School District, a student who is sexually harassed by a teacher may only recover damages from a school district if an official with authority over the teacher knew about the misconduct and was deliberately indifferent. Notice the court had the same ruling in the last case. So that's one of the reasons that we want to make sure that we alert our site supervisor. That person, as you are aware, will certainly want to contact the superintendent of schools so that the superintendent can immediately contact the attorneys on retainer, start to prepare to defend the school district against this allegations, and to protect them from any additional liability. So we know that we've got to inform the principal or vice principal, and if they don't do anything, turn their head, deny that it happened, pretend it didn't happen, or take no action, then the district is going to be liable. I'm going to take a couple comments after this, or questions after this segment, and then we'll be taking a 15-minute break. Any questions or comments? Yes, please.
I think your situation, the scenario you gave, that certainly has happened and is probable. It seems like one of the more common scenarios would be that you heard it as a rumor. That you heard it from a friend of a friend of a friend, or a friend of the girl, that this was happening, and you don't know that it's fact. And I'm assuming that you still have the same responsibility to report it, though you may be very, very afraid that it's not true and that you're setting yourself up for a lot of heartache with co-workers, the student, and the school, and legal authorities.
I've got to repeat her question, and it's certainly a very good one, and certainly more common. I've got to repeat her question, and it's certainly a very good one, and certainly more common. And that is that you've heard from another student, another colleague, or through the rumor mill that Mr. Smith is in fact having a sexual relationship with Innocence. In court, of course, you know, there is the hearsay rule. The teacher in this instance who heard the rumor or was told didn't actually see it, was not actually informed by Innocent that it occurred. But the good news is that there are 22 exceptions to the hearsay rule. And if you have that many exceptions, why do you have a rule? But as teachers, we have a legal responsibility to follow up on these rumors or hearsay. So we have to take them as serious enough to report it to the principal or vice principal. We also, if you're really nervous, the easiest thing is to tell the administrator right away. Let them do the investigation on site. Let them bring Innocence in and question her in a way that doesn't alert Mr. Smith as to what's going on. We don't want him fleeing the state and not being held liable for his misconduct. The other thing is, if you have the kind of relationship with Innocence that she would trust you enough to share this information with you, you could ask her for some information after having alerted the school administrator. Because it involves a colleague of yours, it's easier if you just alert the school administrator and then step back. Let them handle it is the easiest way to go. But you're absolutely right. We do have to report innuendos, report things that come through the rumor mill, things that you heard even in a casual conversation as potential culpable sexual harassment. Absolutely. And thank you so much for that comment.